is like Hamlet asking the question to be or not to be. It's a Hobson's choice. Some people want to make them, some people do not want to make them. There is no law that makes it compulsory for you to make a will, but let's begin with the basic assumption that it would be advisable if you do make a will. As we will go along in this presentation, you'll be able to understand. There are certain myths that follow making of a will. Believe me, these myths are across the nation. It is not restricted to one community, or it is not restricted to below the poverty line community, or to the other kinds or the segments of society. And one of the first myths that follows making of the will is that wills are made only by old or aged people. People believe that wills must be made not by youngsters. A 20, 30-year-old has a probable lifespan of 70 years. So why do I waste my time making a will? This is a myth. The sooner we get rid of this myth, the better for everybody concerned. The second myth that follows is that will is a bad omen, because it is believed that once you make a will, you will die. A will is considered to be a bad omen because the thoughts of making a will only come when you're on your deathbed or when your time has come to leave this world. Neither of these two propositions have been validated anywhere across in the world. Will is a legal document that you make. What does it have to do with your death? Or how does Yama or anybody get the information given the best technology possible? I don't think Yama would ever get the message that Mr. Shivkumar has made a will. He's ready. Let me switch off or come and take him. So these two are completely contradictory and completely unbelievable myths. Will is not a bad omen. It's in fact a best omen that you can give to the people you leave behind, and certainly not a bad omen. Making a will does not hasten death. It is not in your control. It is somebody else's domain. And finally, the myth is that a living will and a will are the same. This confusion has arisen today because the Supreme Court, in the case of Shanbag, which was a case in Bombay, medical case, while dealing with the question of euthanasia, active euthanasia and passive euthanasia, the subject of a living will came up because in some other countries, there is a possibility of making a will which prescribes what are the medical treatments that you should not be given or that you're not willing to take. So it is in the field of restricting medical benefits for you, medical treatment for you, that a living will came up to the picture. The Supreme Court has today said that we will not accept the concept of a living will, but we will substitute it with the word advanced medical directives. So an advanced medical directive is something like a living will, but is not the same will that we are going to be talking about today. A living will refers to medical processes. The other kind of will that we are going to be talking about relates to your assets, both movable and immovable. So these are the four fundamental myths that one needs to completely get rid of before you can take an objective decision as to what you want to do with your properties that you may want to leave behind. Keeping that in mind, let's move on. We need to understand very clearly some of the technical expressions we lawyers and law has created, making it so difficult for the common man to understand. One is called a testator. A testator is a person who makes a will. An attester is a person who witnesses a will. We call them as either witnesses or we call them attesters. The third term that we need to understand is something called testate succession. A testate succession is where a will is actually in place and the distribution of the assets that belong to you, both movable and immovable, happens in accordance with the directions that you have mentioned in the will. That's called a testate succession. An intestate succession is a situation where a will has not been made, and therefore the distribution of the assets of the person who has died will not be under the directions that you have issued, because you have not issued any directions, but it will be according to the personal law of the person who is dead. Muslim law has its own law of succession, Hindu law has its law of succession, Parsi law has its own law of succession, and Christian law has its own law of successions. For example, in Kerala is the matriarchal system. In the other places, it's patriarchal system. It's adequate for today's presentation for you to keep in mind that when we use the word testator or any of these expressions, we refer to the definitions that are found on the right side of the column. Now, what are the immovable assets and properties that law recognizes, which can be the subject matter of a will of any person? It can be urban land, plain, urban, undeveloped land. It could be buildings. It could be apartments. This does not necessarily mean that apartments should have been completed. Even incompleted apartments could also is treated as immovable property and is an asset that belongs to the person in whose name the agreement stands. Agricultural lands are considered property. Leased properties and leasehold rights. Suppose you own a property, then you are known as the lessor or the person who owns the property. The right is yours because the property is yours. Suppose you have leased out that property to a commercial entity. Suppose there is a hotel running in the place that belongs to you, but you have rented it out to them or have leased it out to them for a period of 30 years or 50 years. That period of 50 years also becomes an asset. It's also treated as property because it is deemed to be a right in that property. Then there are commercial properties as opposed to residential buildings, where you have rented out shops, hotels, theaters, malls. These are all known as commercial properties. And apartments which are under construction are also considered to be immovable properties because there is a right that is created by virtue of an agreement, and that right authorizes you to get ownership of the apartment that is under construction. So there is a period of 12 months for completion of the apartments. You have a right to get that apartment at the end of 12 years. This will also therefore be considered under the broader heading of immovable properties. Why I am spending time on this is to explain to you that these are immovable properties as a category of assets which can be disposed of or be the subject matter of a will that you may want to make. Then what are movable assets? What do you think movable assets are? It's a long list. Most of these would be very common to you. Bank accounts, fixed term deposits in banks, bank lockers, deposits with companies and others, mutual funds, shares, debentures, demat accounts, creditors' dues, jewelry, your personal effects, maybe including the $15,000 pipe that you may be smoking, furniture, gas, telephone connections, vehicles, household goods and consumables, email passwords. Remember, all of you, I'm sure, have some emails. The password to the email is also considered to be an asset, which belongs to you, entirely to you, you're owner of that password. Contents of the hard disk and computers. You may have written stories. You may have recalled all the lovely time you have had with your girlfriends when you were young and handsome in the colleges. All those, by the way, constitute your private property. And if it is on hard disk, that is your property. Then there is copyright material. You may have written articles, you may have bloggers, you may have whatever. All that is copyright. Heirlooms. You may have some property that has come down for generations from your father, from your grandfather, great-grandfather. These are known as heirlooms, artifacts, curios, and very curiously, pets. Pets are also your properties. You can bequeath a pet to somebody you feel like and give directions and say, this is the way he shall look after the pet. In fact, I think somewhere in Europe, I don't remember the name of the country, the large cash benefit, a large component of cash has been bequeathed to the pet, and the person to whom the pet has been given has been informed to use this money for taking care of the pet. All these constitute will properties. Why should you make a will? When do you make a will? What is a will? And how do you make a will? This will only be a broad introduction into the whole subject. As I said, you may ultimately need professional help in getting these wills done. Now, who can make a will? Any person over the age of 18 years can make a will. That's a minor. The Indian law recognizes majority as 18, and therefore a person over 18 years of age can make a will. The second condition is that this person must be of sound mind. This is the critical factor in succession law. A person who makes a will must be of sound mind. It means two things. He must understand the consequences of the act that he is doing and also understand what he is doing. Suppose a person who executes documents believes that he is executing a sale deed, but he is actually executing a will. Then he is not in a sound state of mind. If he is not able to understand the difference between the two, if he is not able to understand that I am making a will under which I'm parting with my assets, and I know what the consequences will be, he will not be deemed to be in a sound state of mind. And unless a person is in a sound state of mind, any will that comes out of that state of mind is not considered to be a valid will under the law. A hearing and visually challenged and mute persons can make wills. There is nothing wrong, because what we look at is cognitive abilities of the person making the will. The question is, can this person who is visually impaired or hearing impaired, does he understand what he's doing? Does he and has he understood the consequences of what they're doing? If they are, then there is no restriction in law in making a will. An insane person can also make a will, provided he is in one of those lucid intervals. In mental law, a person has a lucid interval when he is not in a state of mind where he is unable to understand the consequences of his action. Consequently, a person who is generally insane or usually insane, but has lucid intervals, during that period, he or she can definitely make a will. But look at this, a person intoxicated or unable to understand the act cannot make a will. Those of us guys who go for a binge on 31st night and don't know whether we're going left or right, don't know what we are saying, don't know what we are talking, don't know what we are doing. These people cannot make a will at that point of time. So if you're in a completely drunken stupor, if you make a will, you cannot tomorrow go to the court and say, I was drunk, but I know what I was doing, I was making a will. The law will say, bad luck, guy. You were intoxicated enough not to know what you were doing. Therefore, you cannot make a will at that point of time. Get over the hangover, come back to your senses and make a will perfectly all right. And finally, a married woman can dispose of her property independently. The operative word here is independently. This implies that if a married woman has a property of her own, she need not listen to her husband in the disposal of her property. She may be forced to listen to him in other ways in her life. I don't know. I don't want to get into that aspect because that is matrimonial law. Whether the husband listens to the wife or the wife listens to the husband is an independent action that happens within the four walls of your room. But insofar as property is concerned, a woman in law is entitled to dispose of her property in any manner of her choice, completely independent. When can you make a will?
Sir, a couple of questions, sir.
Yeah.
Have come in. What about joint property held by married people? And what should the will of each joint
Can I come to that later,
say?
since we are going to talk about it anyway?
There is also a question that comes in about the Pagadi system.
The Pagadi system lease we will park for the last one. Because that is peculiar to
Okay.
Bombay. It has not yet permeated down to Bangalore and so on, but I will address that issue. That
Okay.
question I will park later. The
No,
other question,
there
joint
was this
property.
neurodiverse question also.
And yes. And also neurodiverse. What about neurodiverse people? Can they make a will?
Yes. These two I will park for the last. I will answer the earlier one about joint property. If two people, husband and wife, own the property jointly, unless the document of ownership specifies a certain share of each of them, the law presumes that each of them own an equal share in the property. But if the sale deed says, or the document says that the husband has contributed 70% for purchase of the asset and the wife has contributed 30, or vice versa, then ownership of that asset is restricted to 70% to one and 70% to the other. This is called joint ownership. It's not necessary that there should be only two people owning a property. There could be multiple people who are owning the properties. And each one's share will be dependent upon how much they have contributed for acquisition of the property. If that is not specifically mentioned or stated in the document, it is an equal division amongst all the people who own the property. But let's talk to only about two people, joint property. Let's say husband and wife. Husband owns 50, wife owns 50. What the husband can do is to dispose of his 50% in any manner of his choice. The wife can dispose of 50% of her share in any manner of her choice. Now, how this is to be, what are the options available? We will come to a little later when we say what to make a will and how to make a will. The second question was what? Neurodiverse, and the other one is Pagdi system. The Pagdi system, both of these I'll address at the end of the show. Is that okay?
Yes, sir. Thank you, sir.
Right. So the will can be made anytime one becomes a major. Will can be made, and according to me, must be made whenever there is an acquisition of any asset, be it a movable asset or immovable asset. Then as long as you're in a sound state of body and mind, please make the will. Do not make this will when you reach a stage where your cognitive abilities and understanding abilities become low. So the ideal suggestion is to make it when you're in a sound state of body and mind. Please remember that a will once made can be altered every day if you want to. It's not a document like a sale deed, which you can cancel tomorrow, make today, cancel tomorrow, make one more tomorrow, make cancel one day after tomorrow. This is known as a testamentary document. A will can be altered as many times as you want. Maybe this change may be determined by your approach to people, your desires, your intents, or any other event that has occurred to make you change your mind. For example, we had a person who had bequeathed all his property to his two children. He was in a bad state of illness. He was not expected to survive. But he believes that due to some miracle of a miracle man, let us not mention names, he got completely cured and he was up on his feet. He therefore canceled the will and handed over and bequeathed all his properties to this religious institution that he believed. So what triggers the change is up to you. But the law recognizes that the change can occur as many times as you want, because the will which is last in chronological order will be considered to be the valid will. So if in a month you have made 30 wills, the one you made on the 30th day will be considered to be the valid will, provided you are in a sound state of body and mind. It is also relevant to remember that if you keep changing your will every day, every morning, a lawyer like me will stand up in a court, before a court, and say, the fact that the man changes his will every morning itself shows that he's not in a sound state of mind. It can be argued both ways. The man had nothing better to do, and therefore he kept having fun, changing his will every morning. I would probably argue before the court that this is not a sound state of mind. Why should you make a will? You necessarily should make a will because it ensures the distribution of your assets as you want it in the manner you desire. You want your assets to go to a particular section of your family, particular members of your family, particular relatives of your family, somebody you love, somebody you care for. It ensures that your assets go to them. Because if you do not make a will, then it goes according to the personal law of distribution of your assets in the manner you desire. More important than that, ladies and gentlemen, it prevents distribution to persons you wish to disinherit. You may not want to give the property to somebody. And there are multiple reasons for this in a large family, in today's families. My son may have married from outside of some caste. My daughter may have run away with somebody and eloped with somebody much against your wish. These two acts together might have caused you a lot of agony and trauma, and within your society, as they say in Hindi, what has happened to the status, I can't get the correct Hindi word, but samaj mein hamare bare mein kya sochenge vagara kind of thing will happen. You may therefore want to say, I will teach both these guys a lesson. I will not give my property to either of them. I will give it to a third person. If you don't make a will, by virtue of the fact that they are your son and your daughter, the property will necessarily go to them even if you don't like it. It is therefore a guarantee against intestate succession. Intestate succession means the directions it will go to people whom you do not want to give it to, because the personal law of each community takes over. As I told you earlier, Muslim law, Hindu law, Christian law, Parsi law, they all have different laws of succession. You can prevent that law from being operational if you do make a will and specify to whom these properties shall go. It enables you to make charitable bequests. If you want to make a charitable bequest to a religious institution, to an educational institution, to an orphanage, or whatever you consider in your scheme of things to be worthwhile, you have to make a will and give it. Because if you do not make a will, these charitable bequests, the people you want to make charitable bequests to, do not come under the classification of heirs under the personal law. Under the Hindu law, for example, heirs are the children, the mother, the children's children, and so on and so forth. It is restricted to family members. A charitable institution is not a family member. And therefore, if you wish to make a charitable disposition to a charitable institution, you will necessarily have to make a will and say in as many terms that this is the amount or property that I wish to give. Obviously, then making a will avoids future disputes and litigation amongst family. And why I make this specific references in today's cross-border transactions, where practically somebody in each family is staying abroad, and the rest of the people of the family are staying in India. The disputes arise most often in those cases where a member of the family who is residing outside the territorial jurisdiction of India questions the will on the ground that the will is an unfair document. I have not got anything under the will, and because I have not got anything under the will, this is a fraudulent document. It creates friction, it creates disputes within the family, and disrupts relationships which you as head of the family may have actually worked for 70 years to get and put together. And finally, why should you make a will? It ensures protection and safety of your spouse and family. It is common knowledge, at least in the area of elder care that I have worked, in the BPL families, in the middle class sector, in the lower income group sector. Once the property changes hands from the father to the son, the mother, who is the spouse of the father, is thrown out. She is abandoned. And therefore, one of the reasons why we suggest making a will is for protection of the spouse, be it the husband or the wife. Or for that matter, you may have a disabled child. You may have a differently abled child. You may have a particular person whom you want to care for. All those get thrown out of the window and safety and protection of those members of the family will also no longer be on the radar of those people to whom you give the properties. Therefore, we suggest that you make a will. Where do you make a will? You can be made anywhere and signed anywhere, except after you've had one too many in a bar. You can do it anywhere else. One caution, if you have assets in India and abroad, please take care and ensure that there are separate wills that you make for assets in India and outside of India. For a very obvious reason, that law is different in each country. The protocol for registration of a will differs in each country. The law and its procedures different in every other country. And more than that, there is a global clubbing of assets once you have a common will, which results in financial liabilities in terms of succession taxes, estate duties, and so on and so forth. In fact, if you are entitled under the law to make separate wills for separate properties. If you have 5 properties, you can make individual wills for 5 separate properties. Why do we suggest this? Let us say you want to sell one of the properties and keep the other 4. The purchaser who wants to buy that property will ask you for the original will. You will not want to part with the original will because it contains references to the huge, humongous amount of properties that you own, including 4 other properties. One way out of this dilemma, therefore, is to create a separate will for each property. And on a lighter note, if you are one of those lucky or unlucky ones who have more than one partner in your life, then you can make a separate will for each partner. That's also allowed, by the way, so that each one doesn't know what the other one has got. I am always reminded of a long time ago, when we talk about multiple partners and multiple wives and so on. Mr. Palkhiwala, who was one of the leading taxation lawyers in Mumbai, was speaking in the Mumbai Hall on one of the union budgets. And there is a concept known as Hindu undivided family in the Hindu law and so on and so forth. So one Mohammedan gentleman, Muslim gentleman, stood up and asked, he said, why is it that, no, I think Hindu gentleman asked, why is it that Hindu law allows only 1 wife per person, while Muslim law allows 4? And Mr. Palkhiwala was not the one to be taken aback. He looked at him for a minute and said, look, Mr. So-and-so, it's not the question of allowing 1 wife or 4 wives, but please remember, whichever law, you will be dealing with 4 mothers-in-law. Then what? That was his response. Anyway, that apart, that was just a thought that came to my mind. The subject being, you can make separate wills for separate assets, and we suggest that you do so. And finally, remember, please, please, please do not make a will in hospitals. Do not wait for a time until you're admitted into a nursing home and on your deathbed with tubes running into you and outside of you, you're on a ventilator, you're on this medicine and that medication in an ICU. Do not make a will at that point of time. Do not wait for that moment to occur before you make a will. What happens then is a doctor's certification becomes necessary. And the doctor can at best certify and maybe give a certificate that your cognitive abilities are in good shape, you are understanding the consequences of your action, and therefore you are making the will. But also remember the other side of it, that the human mind is not capable of accepting suffering as a part of life. When you are in pain, be it physical or mental, the consequences of what you do at that point of time are not necessarily logical, not necessarily acceptable in the eye of law. So as far as possible, before you reach the stage of being taken in an ambulance or in a car to a hospital and being admitted, please get your affairs in order and make a will and keep it ready. Now, what is a will? A will is a testamentary document directing disposal of your assets in the manner you desire. A testamentary document is different from a sale deed, from a gift deed, from a mortgage deed, and other kinds of documentation that we refer to commonly in law. A sale deed, for example, transfers ownership of the property the moment you sign and register the sale deed. Whereas a testamentary document comes into effect only after the death of the maker. So you postpone the transfer of ownership. That is why this is known as a testamentary document. A will is known as a testament. Last will and testament of so and so. Testament means I dictate that this is what should happen after my death. I direct that this is what shall happen. The advantage, therefore, of making a will is that it ensures direction, a disposal of your assets in the manner you desire. Second, the law will enforce the directions that you may give in the will, whether or not other people are dissatisfied or unhappy with the contents. Please remember, if, for example, you have given more to your daughter and less to your son, even though your children may be unhappy with that will, the law will not allow them to fiddle with the will. It will not allow them to change the will. The law will step in to enforce whatever you have put in the will. That is how the testamentary documentation's effect is in the eye of the law. Please remember, a will comes into effect only after death of the maker. And I joined, when I joined King and Partridge as my first office in the year 1971, unfortunately, I was put into this morbid division of wills. And my senior told me only one thing, Mr. Shivkumar, either a will live or the person will live. Both cannot live together. One has to die, then only the other comes into existence. And that is the principle that I have been constantly remembering each time I talk about a will. Don't worry, if you make a will now, nobody can take advantage of that will. Even if you give it to them and say, this is my will, that will is a zero document, is a dead document until you become a dead person, not otherwise. And I said it can be altered any times, any number of times. And the last one will be the valid will.
Sir, if I may interrupt,
Yes.
if I may interrupt on that point, because I think it is important, especially for the senior citizens. So this thing that you say that the will is not effective till one is alive and nobody can, take action on that. Having said that, I have seen many families where the parents wrote the will and one of the children was not happy with what was given to them or not given to them when they came to know about the text of the will, and then they made the life of the parents quite miserable. So even the will is not effective, like by law, it's effective in the minds and in the houses and the families. So, for example, so senior citizen decides, or whoever has written the will decides that I will keep this will hidden from my family members, and it will only come out when I die. Because once you die, you cannot be harassed. Correct?
Not by you, not by human beings at any rate.
Yeah. So if it is hidden, let us suppose, if they suspect that such a thing will happen, then when that person who is in possession of that will and comes and says on the death that I have this will, so what do you think, like what would be the consequences?
I was coming to that a little later, but since you've asked the question, I will tell you, one of the precautions that we advise senior citizens or anybody making a will is, do not disclose the contents of your will to your family. Do not discuss. Most often what happens is the family gets together and says, will you take this? Will you take this? I want to do this. I want to do this. So the seeds of discontent are sown there. Therefore, the trick lies in making the document in the manner you want to.
Yes.
It is your property. And telling your children that this is in a bank locker, the key is with you. And the key is made available only after your death to that person. Or depositing that will with some close known friend or family friend of yours in a sealed cover, which cannot be opened. Have I answered your question?
Yes,
I probably have not. But when
I
you
am a little child, so I don't have the problem in my family, but I have seen elsewhere. It's very rampant. Yeah.
I've seen it, and I've seen it because, and I'm giving you the origin of the problem. The origin of the problem is that our generation of parents believe that we have to be fair to all our children. And in that concept of being fair to children, we get all of them together in the house one day, give them khana and treat them so well. After giving them a solid meal, we sit down and tell them, this is what I want to do with the property.
Yeah.
They will not object at that point of time. The standard response is, Papa, ये आपका property, आप जो चाहे वो कर लो ना, हमसे क्या पूछ रहे हो? वो घर से बाहर निकले ना तो शुरू होता है. या उसकी बीवी झगड़ती है, या वो son-in-law हो तो son-in-law will charify or the daughter-in-law will charify. What a fool you are, I say. Are you stupid? He's giving that property to him. That property is earning rent of 12 crores. You're letting him go. This will start.
Yes, and then of course that joke, you must have seen the ad, मैं शांति के साथ जीना चाहता हूँ.
बिल्कुल, वो तो है, वो तो है, वो तो है भी शांति. अरे अरे हमारे जमीने में हमको एक शांति मिल गया, मैं भी जी लूंगा उनके साथ. So the point is, as we will go on in the last few slides, one of the cautions we issue to people who make a will is, it's not a public document. Do not make it a public document. Keep it. It's your property. Do what you want to do with it. Just like when you become elder and senior, learn to do what you want to do rather than doing what other people want you to do. So drop your will, seal it in a cover, put it in a place and tell your children, this is where it is. The key is with me. Put it on your neck, on your chain or wherever. आप तो डालते हैं चाबी के, घर की जो बहू को चाबी देते हैं ना, पहले उसके साथ लगा के रख लीजिएगा. And write a note saying this shall be opened only after my death. The bankers today have a facility where you can keep it there and the bank will not allow the opening of the locker until the death certificate of the person is produced. That is also possible. But the simplest way of doing it is either keep it in a place where you know where it is and nobody else knows, and leave a note that this is where it is, or give it to somebody whom you trust implicitly and say, give this to them only after my death. Have I reasonably convinced you of sense in my argument? She's off? Okay, all right.
Yes, yes, sir.
I'm all right, okay. Registration of a will with a sub-registrar is not compulsory, but we advise it because sound state of mind. If you make a will outside, it is possible that some members of your family will turn out in a court of law and say, Mr. So-and-so was not in a sound state of mind when he actually made this will, or that he was forced to make a will. Whereas if you appear before the sub-registrar, there is prima facie proof. It is prima facie evidence that you in fact appeared and that you were in a sound state of mind, and you have done this voluntarily without anybody's influence. Therefore, we say, even though it is not compulsory, please do have it registered. In Karnataka, the registration charges are only 600 rupees. In Maharashtra and other states, the registration fee may differ, but the process of registration remains the same. Okay. Let's see a little.
Sorry.
Yeah.
Sorry to interrupt you, sir.
Yeah.
So, somebody is staying in Mumbai and they are having that immovable property in Mumbai, but some banking accounts in Bangalore. So where we had to make the will?
Either Mumbai or Bangalore, either way, either place.
Okay, thank you. And the person who is not having having children, so how to make the will?
Give it to me.
So sweet. Sir, seriously, I'm asking.
I'll tell you. If a person doesn't have children, and you are a single person, in the sense you have no husband, you have no family, your parents are dead, and you're alone with tons and tons of properties, then you can choose whom to give it to in any manner you want.
Yeah.
You can give it to your uncles, your aunt, your nieces, your nephews, your friends, your charitable institutions, theater groups, dance groups.
Okay.
Happy2age, NGOs.
Okay, is it necessary to make different categories for different the different wills for these different categories, or in the
Okay.
same will it can be mentioned?
Same will it can be mentioned. The
Okay.
original will be retained with what we call an executor. In such a
Okay.
case, you'll have to appoint an executor who
Huh.
will actually take charge of all the properties and
Okay.
ensure that the directions that you have issued in the will and the amount of money that you want to go to every organization, he will ensure that it is given to them.
Yeah, is it compulsory to mention each and everything that we have our the accounts? It may be increase or decrease when till the death.
I will
So
come
is
to
it
that. That's on the next slide. I will come to that.
Oh,
I'll give you that.
okay, okay. Thank you, sir. If any doubts, then again I will interrupt you.
Please, but I can't see you. Who is interrupting me? I don't know your name also.
No, Jayashree from Mumbai.
Okay. You're most welcome to interrupt. No issues. I enjoy it. At least.
I opened this video also. Can you see me?
No, I am on the screen. Anyway, it also gave me the chance to tell you that if you find nobody else, Shiv Kumar is always available for receiving.
Yeah, sir.
No
Sir,
problem.
definitely, sir. If I need, I will come to Bangalore and I will meet you definitely.
Not meet me. I'm saying if you don't know who to give your properties to, give it to me.
Okay. It is okay, sir. Thank you.
All right. Okay. Let's move to the next one. Let's say more about wills. A will must be in writing. There is no concept of an oral will, except in the case of privileged wills. A privileged will is a will that is made by defense officers while they are on duty. They are also entitled to make oral wills, and they are known as privileged wills. But otherwise, a will must be in writing. It must be signed by the person making the will, that is the testator, or if he cannot sign, he must affix some mark. Like Musk has made X his mark. You can make your mark and say, this is my mark. And that has to be signed by another person in the presence of the testator and under the directions of the testator. So what the line will say, I so-and-so have affixed my mark. I have authorized Mr. So-and-so to sign on my behalf, and I have issued directions to him to sign it. That is also permissible. It must be attested by at least 2 witnesses. There are 2 witnesses, or attestors as we call them. These 2 attestors must actually have seen the testator signing the will. Most often what happens is the will is signed at home, then it is taken to the house of the friend, who also certifies that I have seen the testator signing the will. That is against the law. A testator must sign the will in the presence of 2 witnesses. But both witnesses need not sign at the same time. In other words, both 2 witnesses need not, it is not compulsory that 2 witnesses be present at the same time when the testator is signing the will. The testator can sign the will and the witness can come once, 1.5 an hour once. Some other day, another witness can come and the signature will have to be signed then. Please remember very, very carefully, a person who signs the will cannot be a beneficiary under a will. A beneficiary means a person who receives something under the will. Whoever signs cannot be given any gift under the will. He cannot receive anything under the will. This is something very, very important, because most often what happens is the son or the daughter is asked to sign as a witness to the will, and both of them are given properties under the same will, which is not allowed in law. Then, executor. Who is an executor? An executor is a person who steps into the shoes of the testator and ensures that all the directions and commands that have been issued by the testator is given effect to. An attestor can be an executor, but an attestor cannot receive any benefit under the will. What happens when you make a will if you are not married and you subsequently get married? The law says the will is automatically revoked when marriage happens. A fresh will is therefore required to be made after marriage, because the concept of family then gets expanded. The third point I'm going to make is the most important thing in any will. It is the intentions of the testator. It is not very important that the words must be so clear and must be so unambiguous, but whatever words are used in a will must be capable of identifying the true intent of the testator. What is it that the testator actually wanted to do? What is it that he did not want to do? This is where we say, please get to a professional, because there must be clarity in what you want to do. Let's say you want to give to your wife, or the wife wants to give to her husband a property for 10 years only. And after 10 years, you give it to somebody else. Can you make such a will? What should be written there? What are the terms, technical expression, and words that should be used? These are all items that are better judged and better done by professionals who have had years of experience in drafting of wills. A will cannot be a document which is capable of multiple interpretations. Because if two people have different interpretations of the same clause in a will or the same language in the will, which reflects a possibly different intention of the testator, believe me, that the matter will go to the court and the court will sit in judgment over what the testator thought he meant. Why leave it to a third person to decide what the testator's mind was? A testator's mind must be clear. What he says must be clear. If he wants to give it to Mr. X, he will give it to Mr. X. If he wants to give it to Y, he'll give it to Y. We have had instances where in the first paragraph of the will, a particular property is given to the son. But by the time the senior citizens writes or makes 4 more paragraphs of that will, he gets tired. He goes out. He has his evening tea, coffee, or scotch, or whatever. 5 days later, 6 days later, he suddenly remembers, oh my God, that will is incomplete. Let me go and complete it. Starts rewriting the whole thing. And by the time he comes to the last paragraph, you forget that the same house you have given to your daughter, you give it to your son in the last paragraph. Now nobody knows whom did you want. There was a will which we constantly use in training, which says, I have a portrait which is 150 years old. I give this portrait to the child, to my child who loves me most. There are here 3 children. Now, who and how will you figure out which child loved him most? The matter went all the way to the court. Therefore, the language has to be so clear, precise, and unambiguous that there is no room or scope at all for trying to even interpret the intention of the asset of the testator. Then it must relate to the assets that are owned by the testator, obviously. I cannot give away the Rashtrapati Bhavan to somebody because I don't own it. You can't give away Juhu Beach to somebody because you don't own it. In this context, therefore, when one asset is owned by more than one person, that person can give away or bequeath, as we call it, only that portion that he actually owns and not anybody else's. If I own a 1/6 share in the property, then I am entitled to gift or bequeath under a will only my 1/6 share of the property. So this must be actually owned by the person. Now take Binami transactions, for example. In most cases, the husband, who is the earning member, buys property in the assets of the wife. And at the time of making the will, the husband says, this is my property. I will give it to my daughter. The wife says, no, the sale deed and documents are in my name, even though you paid for it. So I will give it to my daughter. Now, who is the actual owner under the law? The actual owner under the Binami Prohibitions Act is the wife and not the husband, even though the money may have come from him. So when we talk about assets that are owned by the testator, it is owned in accordance with law by the testator. When there is therefore a doubt, This is the reason why we suggest please get to a professional. He will clarify for you who owns the property, and then you can give that property away. There is also provision in law for making a will in respect of properties that you don't own today, but you may own after you make the will. You may have two properties today. You may, during this, for some reason, you may get some money and you may make one more property. That is made after you have executed the earlier will. Does it mean that you have to make another will? You can if you want to. The law does not prevent you from doing that. But in the same will, we use what is known as a residuary clause. And that clause says that all the assets that I own, be it movable or immovable, that I may acquire after this date of making my will, I will give to whomever you want to give. It becomes included in that clause. The critical words here are, what are the assets that you die possessed of? What are the assets that you own on the date of your death? That is the benchmark. You may own some when you make the will. You may acquire some after you make the will, but the will refer to all the properties that you own on the date of death. The same thing applies even when you don't maybe have a grandchild yet somewhere in the offing. You have made a will and you say that this property shall go to my daughter or my son. But you also hope that during your lifetime, you will see a little grandchild or a little grandson or a daughter, and you want to make some property, some bequest to the property. You can make it in this will itself. And you can say that if I have a grandchild on the date of my death, some portion of this property will go to that grandchild also. These are all provisions, not only relating to assets that will come into existence future, but also to people to whom you want to give it, who may come into existence in future. If you have made two inconsistent clauses in the will, one says one thing, the other says the other thing, the last clause will prevail. That is a provision of the law. Now, there is something known as contingent bequest, meaning you can make a bequest and say, I give this property to my nephew, provided he gets married on or before such and such a date. Possible. Or you can say, this property will go to him if he remains unmarried even at the age of 95. We do that. No issues. Conditional bequests are also permitted, meaning if my grandchild gets the first rank or gets admitted in the University of California, this property will go to him. But you cannot have a condition that are impossible to perform. To give a most ridiculous example, if you say, I will give all my properties to my little nephew who is 6 years old, if he can make two parallel lines meet, it's not a permissible bequest under the law, because it's inherently impossible to do so. But other kind of conditions are okay. What happens in the case of simultaneous deaths? This is something that bothers people a lot. All of you are traveling, let's say for entire family is traveling on an aircraft, and the aircraft crashes. What happens? You're all dead simultaneously. You all made wills. What happens? The law finally, it's a very interesting proposition of law. In the case of simultaneous deaths, where there are wills that are in existence, the time at which the first person died becomes relevant. Who died first? It could be a matter of seconds. It could be a matter of 2 minutes or even 30 seconds. If the father has died first, then that will come into existence. If the mother has died 3 seconds before the father, that will come into existence. So in the case of simultaneous deaths, it is a huge liability cast on the law to tell you who died first. I'm telling you, it's a horribly morbid subject, and I really don't know why I'm spending so much time on this, but it's for information. It's constantly about deaths, deaths, and deaths. So in the case of simultaneous deaths, therefore, ladies and gentlemen, it's very dependent upon, not on you. God knows who died first, but some guy who does postmortem or somebody will tell you who died first. And that's how succession will go on. There is something known as mutual wills and joint wills. In case there is property owned by the husband and the wife, both of you can make a joint will. It need not be these two separate wills, but it can be two separate wills if you so want. And a mutual will is something where the husband says, I give everything to you, and the wife says, I give everything to you. This is known as joint and a mutual will. A final couple of more slides on this. And appointing an executor is not compulsory. It is not compulsory to appoint an executor, except in the cases that I think Jayanshi mentioned, where there is nobody in the family. You want to give it away to half a dozen people. Appoint an executor who takes upon himself the responsibility to act in accordance with the directions of your contained in the will. Probating a will is not compulsory in India today, though it was earlier on. It is not required. No stamp paper is required for a will. It can be on plain paper. Registration will also happen on plain paper. A will can be in the handwriting of the testator. If you don't want your will, the contents of your will to be known to anybody else, you have the privilege of writing it in your hand, provided you can read what you have written. Leave alone later on, they can read what they have written. If you want to revise the will, you should be able to figure out, man, what's this I've written here? I don't think I can figure out what I've written here. And that is one of the grounds on which the validity of a will can be challenged by saying this was not his handwriting at all. It's very crucial to remember that your handwriting when you're 15, 20, 30, 40, 50, 60 will be materially different from your handwriting when you're 70 and 80. So try and not be a martyr. Try and not prove to yourself that you're still as capable as you were when you were 25 years old. It's perfectly acceptable to have it typed, get to a professional and sign and get it witnessed. Please remember, another myths about the properties are, you cannot control the way the beneficiary deals with the property bequeathed by you. If I bequeath my property to my wife and say this property yours, I cannot add there and say, after my death, you shall give this property to so-and-so. I can't control the manner in which the person to whom I have given the property must act after my death. That is not permissible in law. Because when you give away property, when you bequeath the property under a will, you are making that person the absolute owner of that property. And he or she has absolute right to deal with that property in any manner of that choice. So you cannot add a clause that you say, I give this property to you, but you shall not give this to somebody else after my death. That is not permissible in law. What is the process finally, ladies and gentlemen? First, take out a piece of paper, make a list of all the immovable and movable properties that you've got. Names, numbers of the property, flat numbers, property numbers, sale deed under which you purchased it, the khata number, everything. Make a list on one side. Second list, make a list of all the investments that you have made. Bank accounts, mutual funds, shares, debentures, deposits, gold, jewelry, whatever you have on the other side. Don't show it to anybody, but keep it to yourself. Then the third list, the most important. Determine the beneficiaries. That is, to whom would you wish to bequeath your assets? Whom would you like? If you have 3 properties, which property should go to whom? Which shall not go to whom? You have 5 cages of jewelry. How shall I distribute it? Who shall get what? Make a list of that, then mix and match and arrive at a conclusion as to which of your assets you want to give to whom. And then consult a competent advocate for drafting. As I said, do not create a document which requires interpretation. And finally, though it is not compulsory registerable, do register. What are the common challenges to a will in a court of law if a will is to be challenged? The testator was not in a sound state of mind and body. This is the most common thing. Or that he was forced or compelled by a family member or a caregiver. As I gave you the example of one child in the US and one child here, the challenge to the will be this particular son whom he was staying with has compelled him to make this will in this manner. Or a caregiver. 24/7, there are caregivers today. It may be challenged on the ground that this particular caregiver forced this man to make a will in this manner. Or it was signed when in a state of pain or intense emotions, or under threat of deprivation and abandonment. Mr. So-and-so, I will refuse to give you your medicine today unless you sign. Mr. So-and-so, you will not get your soup today unless you sign. Mr. So-and-so, I will not change your nappies, even though you have wet your bed, I will not change it unless you sign. These are all known as threats. These are duress. These are compulsions, which is not any longer in the realm of imagination, ladies and gentlemen. This is happening in real life today. Not necessarily in the BPL families, not necessarily in the uneducated families, but is a common feature among the most educated and well-to-do families. And the reason for this is whatever you give in your will comes to the beneficiary, hookup, as we call it, comes free of cost. It's not their property, it is your property that is adding to their value. The other ground would be was made when cognitive abilities were impaired, when he was not in a clear state of mind. Or that the person executing the will was made to believe that it was a will and it was not. Or the other way around, that what he was signing was a sale deed or a gift deed or an affidavit or a declaration, but in fact, it was being a will. And the latest under the law is suspicious circumstances. What the courts are now looking at is, look at the surrounding circumstances to determine whether the testator would have actually done this will in the manner he has done. Surrounding circumstances could be isolation. It could be the family circumstances. It could be the interpersonal relationships that exist between family members, the history of the patient's illness, the history and the relationship between families and family members. Were these circumstances not suspicious? If they were normal, the court will accept it. But if it finds that there is even a trace of suspicion surrounding the circumstances under which this will was created, it is possible that the court will say this will is not a valid will. And of course, finally, that the signature has been forged. The challenge is this was not my father's signature. And this is another reason why we advise senior citizens, make a will when your hand is firm. Make a will when you're not suffering from either dementia or from Alzheimer's, where your finger shakes. In which case your signature itself becomes subject to challenge.